Hello friends, welcome you all on my YouTube channel Law Decoded. My name is Rohit Kumar, and in this video I am going to discuss about the pre-packaged insolvency resolution plan, which is recently introduced by the government by issuing the IBC Amendment Ordinance 2021. So this law comes under Insolvency Bankruptcy Code. So Insolvency Bankruptcy Code is basically a law which is applicable on the company which defaults on payments to financial creditor or operational creditor. So that is a very vast law. I am touching upon only the one part, which is the pre-packaged insolvency resolution plan. So we will go by one in this video. So basically in the introduction part, this is introduced by IBC Amendment Ordinance 2021, and by virtue of that a new chapter 3A in the IBC 2016 is added, and this is the ordinance, so we can expect an amendment into the act to incorporate this ordinance as a law. So before the expiry of this ordinance, you can expect an amendment into the IBC law. So what is the meaning? And I would say the meaning and the purpose is quite interrelated. So the meaning is pre-packs are essentially a form of the restructuring that allow the creditor or the debtor. So it's basically an arrangement. When you read the word restructuring between the creditors and the debtors to work upon some plan or have some arrangement to run the company. So as I said, insolvency law applicable when there is a default. So whenever there is a default, the first step is to check whether the company is solvent or not. So out of all the efforts done by the government, this is the one of the way to resolve this issue of default, because this is the major reason in contributing to the bank NPA, non-performing assets. The more default on the corporate side, the more will be the NPA in the books of bank. So this is the a shortcut and the shortest way to resolve this issue. So this is the very informal meaning. So what is the basically the pre-pack plan? It's just simply arrangement between the debtor and creditor. It's like an agreement or a private process wherein some sort of relaxation provided by the creditors. So let's go to the applicability part. So as I said, it is applicable for the MSME. So MSME defined under section 7 subsection 1 of MSME Development Act 2006. It also includes the partnership, because till now what we have seen under the IBC, only the corporates are dragged in the NCLT, but this process is also applicable on partnership firm, incorporated one, so not the unregistered part. And again there is one more check, the no insolvency proceedings in the preceding 3 years. So the company which is going to opt for the pre-packaged insolvency resolution plan should not go for the proceeding, any insolvency proceeding, or there is no liquidation order in the preceding 3 years. Only then the MSME company or a partnership can go for this scheme. And amount of the default has been kept up to 1 crore rupees. It means if there is a default of more than 1 crore rupees, then the company cannot opt for this. So this is a threshold limit, and company has to keep in mind this limit while opting for this. And why I'm saying the company opting for this is a kind of the process initiated by the company itself. It's just like a voluntary efforts, voluntary action by the company, just in the case of voluntary winding up, which is initiated by the company itself, not by the outsider. So this is in the similar line, it's a initiation by the company. It's not like the financial creditors are taking action against the company. It's a company itself opting for this arrangement wherein some sort of haircut is provided, and the amount which is due, can be reduced, or some sort of relaxation by the banks. So what would be the process? Under the process, as it is initiated by the company itself, so the members means the shareholder of the MSME, or you can say the partner in case of partnership firm, can propose this by passing a special resolution. So if it is a company, then the company's member have to pass a special resolution, and there has to be an the prior approval or the assent of 66% financial creditor assent. It basically means financial creditor must agree, at least 66% financial creditor must agree to this pre-pack resolution plan. So if either of the criteria is not fulfilled, then the company cannot opt for this scheme. So member resolution via special resolution and 66% of financial creditors confirmation is mandatory to go for pre-pack resolution process. There is one interesting part. When the company is going for this route, it means somewhere the person who are initiating is within the company. So section 29A is coming into the picture, because section 29A bar promoters and the willful defaulter to present a plan. It basically, in this under the IBC law, normally the resolution plan, it means how the company is going to be resolved, is submitted by some outsider, to whom we say a resolution applicant. So that resolution applicant cannot be the promoter of the company, otherwise it will defeat the the purpose, because then the company deliberately start opting this scheme, and the promoter become the resolution applicant and apply for the resolution, and somehow get the discounting which is provided by the financial creditor. So once the parties agree and the due compliance has been done, the plan can be presented to the adjudicating authority for the approval. Here the adjudicating authority means NCLT, National Company Law Tribunal, and NCLT have to approve that plan within the 30 days. So what would be the effect? So once you start this pre-pack insolvency resolution process, or company opts for this, so this is a very basic I would say the rule under the IBC, that no insolvency proceeding can be initiated. So you cannot initiate, it means creditors, the financial or the operational creditors cannot initiate the fresh insolvency proceedings, and you have to read this with the moratorium. So moratorium, it's like that you cannot file any complaint, you cannot file any case against the company. So moratorium is like the company is at halt, so there is no proceedings can be initiated against the company. Process, again, the whole process must be completed within the 120 days, and this is an important aspect. This during the process, so whatever be the process of the 120 days, the management and the control will remain with the promoter. If you have read the IBC law, in the normal corporate insolvency resolution process, which is CIRP, under that part, the management and the control rest with the resolution professional, not with the promoters or the directors. But in this pre-pack insolvency resolution process, the control remain with the promoter. Sorry, I have written a wrong word. It's not, don't read it as a creditor, it's a director. So this is the drastic, I would say, change in this scheme, wherein the control remain with the promoter and directors. But again, the committee of creditors, basically the financial creditors, by 66% vote, can transfer the management of the company to the resolution professional after seeking the NCLT approval. And one more interesting aspect, the resolution applicant will also get the benefit of section 32A. So the section 32A provides that if the new management or the resolution applicant control or take over the control over the company, they will not be held liable for the action of the previous management. So it might be possible, the previous management of the company have done some fraud, have done some activities which is illegal. So in that case, the repercussion will not fall on the new promoter, I would say, the new the resolution applicant who submitted the plan. So this is the whole process, or I would say the mechanism how this will work. So this is recently introduced, and the government is now will check how it will resolve the insolvency problem of MSME sector. Once this is suited, then the government might extend this plan to the normal corporate which are currently covered under the CIRP, Corporate Insolvency Resolution Process. So I hope you like this video, and it would be helpful for students as well as the person who are working in a company, because you never know when this when there is a default and how you can go about it. Because recently you must have heard a news that in one of the group companies of the OYO hotels, the insolvency proceedings initiated. So it's not like if you are into practice or you are working exclusively in the insolvency regime, then only you should read this IBC code. But in general also, if you are working in a company or you are a student, this is very the important piece of legislation you which must understand. So thank you for watching this video, and if you have any question, then you can ask in the comment, or you can provide any suggestion so that I can improve in my next videos. Thank you so much.